So I titled my presentation, The Past, Present, and Future of Traditional Knowledge, for a number of reasons. One has to do with thinking about the dynamism of traditional knowledge. So we often think about traditional knowledge as sacred knowledge or unchanging knowledge, but that's simply not true. Even outside of the liberal political arena in which intellectual property operates, traditional knowledge has a dynamism. It changes. And so it's important to recognize that, and at least to also identify the intersection between our current types of institutions for globalization and intellectual property and the dynamic social and cultural and economic and political forces that drive traditional knowledge. So that's the broad kind of scheme for my comments. The other two comments are more academic in some ways, so justifications for my titles are more academic. The past, present, and future of traditional knowledge is tied to both the past of traditional knowledge, which is a little bit ironic because we're thinking of academic scholarship that maybe is 15 years, 20 years in the making, but also talking about present developments, but also using this for a future platform to understand traditional knowledge, both from an academic and a policy perspective. And then finally, at a more personal level, the past, present, and future of traditional knowledge is referring a little bit to my own scholarship. So I've contributed with my colleague, Professor Margaret Chan, to the WIPO white paper that came out in 2001, 2002. We wrote a little commentary on the report having to do with systems of trust and legal structures for managing traditional knowledge. And then that commentary became a basis for a 2003 article, which is actually the title of the talk, Globalization, Patents, and Traditional Knowledge, that is on the program. It's a reference to the 2003 paper. And then I also wrote a 2006 paper having to do with the commons, thinking about traditional knowledge in the context of the global commons. And so the 2011, I don't think there's any pattern to this. So 2001, 2003, 2006, and now 2011. Roughly maybe every 4 or 5 years I come back and look at this, I guess. But nonetheless, this presentation today builds upon my work as well as the works of others. So thank you once again, and let me go through some of my commentary. So the first issue to point out, of course, is a comment that will come up throughout our discussion today, and that is the varieties of traditional knowledge, or what follows under traditional knowledge. We often divide the broader notion of traditional knowledge into things like plant varieties, genetic resources, folklore. I would also include things like symbols, traditional religious symbols or cultural symbols. And so the collage that I've tried to do, I hope it can come through, tries to capture various aspects of this, from the Taonga cultural symbols that are at issue in New Zealand, to the upper left-hand corner having to do with the Kani and the whole issue of neem in the context of India. I can gladly take some questions about the background when we open it up to questions and answers, but I wanted to have a collage that looks at the various aspects of what we consider traditional knowledge. And if you look at the various aspects, you have cultural symbols, you have traditional Chinese medicines that are in the middle, you have the Zuni symbol that was at issue in the US, in New Mexico. And you sort of see the range both from plant genetic resources to cultural symbols, but also a range from traditional knowledge itself being, to use kind of anthropological language, either raw or cooked, right? And raw or cooked in the sense that traditional knowledge may have some basic aspects that are very fundamental, foundational, on which other people may build, but it also has a cooked aspect. It's also something that itself has been developed into a formal system within a cultural or social norms, if not formal legal norms, as we think about this. So you think about the neem cooking here as sort of this example of traditional knowledge in the raw, and then at the upper left-hand corner, the neem ointment as traditional knowledge is the cooked, the perfected, or the commodified form. And again, this is emphasizing that traditional knowledge is not one static body of knowledge. It itself has its own dynamism into which our legal systems intrude or interface in order to create a new set of norms and a new set of structures. And it's those new set of norms and structures that I want to talk about today, or at least frame our discussion. So there's three sets of issues that I want to kind of interact with The first is this notion of the commons and the way in which the notion of the commons has changed, I think, over the last decade or so, at least at the development of intellectual property. And I think one aspect of the commons, or the theory of the commons, that has become more enriched is to think about issues of distributive and intergenerational justice. And that will be a big focus of at least what I think the normative notions of the future of traditional knowledge might entail, as a way of bridging both the past, the present, and the future. And the third issue that I want to talk about is something that we tend to maybe ignore, largely because of our own, as Dr. Braven talked about, the incentive structures within which we operate as professionals. But we need to keep in mind, I think this aspect of humility is very interesting and a very important one to highlight, but that when we're talking about traditional knowledge, and perhaps intellectual property more broadly, we're often talking about an interface between the legal and the social. And so to give you a very sort of what resonates with me when I think about traditional knowledge, I think, for example, about how intellectual property systems in developed countries have sometimes intruded or reshaped university. We think about university knowledge, whether in the sciences or in the humanities, as being some aspect of traditional knowledge in developed countries. But with developments, for example, in Bayh-Dole Act in the US, and the commercialization, or the kind of the push for commercialization of knowledge within universities, there's a very interesting interplay between what we've considered traditional knowledge, at least in universities, and more modern and postmodern institutions that come up with intellectual property and law. And so that's a very, very useful paradigm for me to think about when now we're thinking about the interface between traditional knowledge systems and structures in developing countries and the more formal legal structures that are coming from as part of the process of globalization. So this is the point that I will end with, is to think a little bit about the interaction between the legal and social in the context of how we think about the commons and distributive and intergenerational justice issues. Okay, so I will I'd probably speak for another 20 minutes or so. I've sort of lost track of time with all the time zone changes and so forth. But I think I can lay out what I want to in the next 20 minutes or so with time for questions. And hopefully the questioning will survive also the coffee hour that we have. So the commons, right? So the theories of the commons inform much of our understanding of intellectual property. And we usually think about the intellectual property commons in many sort of ways. One way, of course, is that there is sort of a common of knowledge, a common of creativity, in which intellectual property intrudes in order to give some sort of proprietary rights. And so those proprietary rights can take the form of a copyright or a patent or a trademark or a trade secret. And those are often given for a short period of time. Now, admittedly, short is a matter of perspective. As we know with copyright, life plus 70 years or maybe even 120 years. But within the kind of the life cycle of culture, it may be not that long. But of course, within the life cycle of what we view as our generational culture, generational sharing of knowledge, it can be quite long. But nonetheless, the idea is that there is this kind of common pool within which intellectual property operates to create some sort of proprietary systems for some period of time, and then the knowledge that generates goes back into that common pool. Right? That's kind of the cycle that we think about as far as the notion of the commons, and we can have obviously policy and other disagreements about the extent to which the commons operates, but it's very different than, for example, the way in which real property systems have evolved. It's certainly in developed countries where there was a notion of the commons, and then you had the enclosure movements in which strong property rights were created, but those strong property rights were often viewed to last forever. They could be marketed, they could be traded, they could be given back to the government and so forth. But intellectual property has a time-limited notion, which suggests that it comes from the commons and then goes back to the commons. And we think about how to structure that particular dynamic. And so we think about the commons having both an economic and a political dimension. The economic dimension often is traced back to political theorists like John Locke, where the idea is that you go back to the common pool of knowledge based upon rich cultural and social institutions, and somebody takes from that common pool of knowledge and develops a product, develops some sort of more cooked type system, which can be proprietary for some time, and then it goes back. And so the idea behind the Lockean system and its variation is that you use this common pool of knowledge, but you don't waste it. You take enough to develop your own musical works, your own literary works, your own scientific discoveries, and then you leave enough in the commons for other people to also build upon this. So there's a long discussion about Locke, and it goes off in all sorts of different directions in modern discourses and theories of intellectual property. Some take a very strong position, having to do, often connected to I guess I would call him a political philosopher, a moral philosopher, Nozick, who has very strong proprietary rights. And then there may be more qualified notions that can be traced to people like John Rawls, that have sort of more limited notions of what that proprietary right might be, but there is this sort of economic dimension to it. But I think there's also a political dimension, and this is one thing that I wrote about in my 2003 piece and also informed my commentary with Professor Chon, that there's a liberal rights notion also to the commons. And so my original kind of take on traditional knowledge was that it allowed certain stakeholders to have a place at the table, if you will, in various international negotiations regarding intellectual property. It gave a stakeholder position to various indigenous communities. It gave a stakeholder position to those who operate within a system of creativity and discovery and knowledge sharing that may not be within institutions like a university or institutions like industry. Right, so it expands the scope of individuals that have some sort of a stake in the broader intellectual property system. And then that not only shapes the way in which the intellectual property system can be more flexible and open, so it's not just simply viewed as multinationals pushing a certain view of intellectual property. It really is expanding this notion of what we think about as intellectual property, not just simply as a system of commodification, but also as a political system. And I still think that's true. I'll give some examples as we go on, as we talk about the role of non-governmental organizations, for example, in India, in giving some position at the table as these broader notions of globalization and intellectual property take place. So when we're thinking about the liberal, the political system, we can think about it as in some ways, and this simplifies quite a bit, but I think also gets the tenor of the political discussion going, as liberal individual rights theory, proprietary systems, not just in economic terms, but maybe also in political terms, versus more communitarian systems. How do we recognize the rights of groups? How do we recognize the rights that may not be purely economic rights that might attach to individuals, right? So we can think about that within a communitarian system as various dimensions of moral rights, if you will, not purely economic. It could also be rights of groups, however the groups may be defined or self-defining. So if you think about this sort of big debate within the commons, I think one area where it really came to the fore is this notion of limited common property. That when we're talking about the property rights system associated with intellectual property, we're talking about some notion of a limited commons, or a limited common property, to take a phrase from Carol Rose. So if you read the anthropologist Michael Brown, who wrote the book Who Owns Native Culture, which I think was a very important book that came out in about 2005 or so, he pushes this notion of LCP, or limited common property, to really understand intellectual property systems in contrast to other types of economic or property rights systems. There is a common, but as we sort of try to formalize sort of notions of Locke, the commons might be either an input or an output. And what I mean by that is, within the Lockean system, knowledge is out there for anybody to use. It then gets used, gets proprietized, and then it goes back to the commons. It goes back to whence it came. And so that's the notion of a limited common. It's not simply communal. It's always open. It's always within the public domain. The public domain kind of has an exit and also an entrance, right? And so we have that shifting going on. Okay, so this is sort of the broad theory, notions of the commons, sort of to give you a sense of how this shapes our understanding of intellectual property and traditional knowledge. And as we all know, this is where we think about kind of the types of ethical issues, the moral hazards of our profession, as I think Dr. Braverman very interestingly put it. And some of that moral hazard comes from the devilish details, right? It's devilish in both senses of the term. Devilish in the sense that these are the things that really are confounding or difficult for us. We have these ideals, how do we implement them, right? The devilish in that sense, but devilish in the same way that we might have these ideals, but we have to, at some level, compromise and come up with sort of limiting principles, and in that way, there is an element of compromise. I mean, the moral hazard, at least in the very narrow sense that Dr. Braverman, I thought very interestingly pointed out, has to do with this notion of political compromise that comes up. So the devilish details that have always come up again in the traditional knowledge debate, and again, it's part and parcel of the broader intellectual property debate, representation. If you're thinking about group rights, what are the groups, who defines the groups, how exactly are the interests of various groups then voiced or find voice in the development of legal regimes and legal institutions. How do we then think about the governance? If we are thinking about a limited common property system or other types of commons, economist Elinor Ostrom tells us that, and I think rightly so, that really the issue is governance of these commons. So we can say that we have a communal system, but exactly what are the rules? Who has the voice? How is exit operated? How do notions of loyalty, to take some categories from the economist Albert Hirschman here, fit into that governance structure? And then finally, in addition to governance, there's the marketplace, right? We don't often think about the market, as you will, as part of commons, but certainly the market is type of commons. I mean, if the idea of a marketplace is an open place, like a bazaar, right? Whether it's the kind of the bazaar that you see in many developing countries, the bazaars you see in India, bazaars you see in Africa or Latin America, that kind of structure of the bazaar is meant to be an open place. It's meant to be communal. Now, within that communal place, there may be private or individual transactions, and the subject matter of that bazaar might lead to certain types of commodification, but the question is, how does that occur? And I think this again resonates with some of the comments from the introduction that the downturn, if you want to call it that, or the next Great Depression or soon to be Great Depression, however you define the period from 2006 and ongoing, it had something to do with sort of the breakdown of how we think about the structure of the marketplace as a communal system, as a public place, which is subject to regulations, subject to rules, and not just simply an arena for private deal making, which, as I read Dr. Braverman's comment, we may have degenerated into in the world of globalization and so forth. So how do you understand that particular place, right? So I'll talk in a few slides about issues of benefit sharing, issues of how transactions are structured. And I think this is actually a very important part of what lawyers bring to the table, not just simply the law as imposed as a set of rules, but the law as a fairly fluid transactional sort of practice in terms of trying to get the various stakeholders together to come to some sort of a common agreement.